So in the mediation, one party is going to have their lawyer there with them, the other party has their lawyer there with them, and then you have an independent lawyer called a mediator in the middle who will not always be in the same room with everybody. Often this party's in this room, this party's in another conference room, and the mediator kind of bounces back and forth trying to get a settlement from here or a settlement from there. That mediator can't offer any legal advice, but usually they are a very seasoned lawyer who's tried a lot of divorce cases, and they have the experience to know in their local county what their judge may do if you try your case, and they can give you really good advice to both sides on how to come together to reach something both sides can live with. When we look at the pros and cons of mediation versus actually trying your case in the courtroom, here's what you got to consider. If you go to trial, everything gets out on the table. And at the end of the day, when you can't reach an agreement, you're in trial, and that judge is going to make a decision that whether you love it or hate it is going to be final. And that's the great thing about a trial is you get some finality to it. But in a mediation, the really big advantage there is that you can reach a settlement that you can live with. Now, both sides have to give a little to get a little, and you may not love everything about your settlement, but most sides get to an agreement whether you mediate for a couple of hours or a full day or even longer than that, where you come up with a solution that you can live with, and you're okay with it. You may not love it, but you can live with it. And when you get there, a big pro for a mediation is that you've got an opportunity to formulate your agreement to something that you're happy with. The con there is that you don't have any way to make the other side do anything. And there's no judge there to make a decision. And sometimes mediations can go on for a long time and still not get resolved simply because the other side is unwilling to give or to come in your direction in any way. So there's pros and cons to mediation. The con to litigation or trying your case in front of a judge is that you don't have any control over what that order is going to look like. Your lawyer should do a great job of putting all the evidence in front of the judge, making sure all of your witnesses testify, asking all the right questions. But at the end of the day, when the hearing is done and all of the evidence is submitted to the court and all the testimony is concluded, that judge gets to make a decision that you may absolutely love, or it may be the worst thing you've ever seen. And then you have to start a long and lengthy and time-consuming process called an appeal, which is a whole other animal you have to deal with. And so there's pros and cons to both sides, but in every single case we have, we always encourage people to do a mediation or at a minimum what we call a settlement conference, where without a formal mediator, both sides get together and try to work on a settlement. Because if you can have control over what your order looks like, most often you're more happy than you would be at the end of a trial. A lot of people ask, if we go to a mediation in our divorce case and reach a settlement and sign that agreement, and then it gets submitted to the court, can we change that agreement later on? Well, the answer is maybe. When your agreement gets submitted to the court in writing, you agree, usually when you sign the agreement, that we agree to be bound by this from the moment we sign this. And then if the judge has not signed an order, what we call ratifying or adopting that agreement as the order of the court yet, it's not officially an order, but you're probably still going to be bound by it unless you can show to the judge that either you were unrepresented or underrepresented, that the agreement is vastly unfair to you, or that you were in some way coerced or required to reach an agreement that day in some way, or at least you felt like you were under duress to reach an agreement that day. There could be some legitimate reasons that a judge could set aside that agreement. I have also seen some cases where people even have already had that order ratified by the court, but since they were unrepresented, we've filed motions with the court to have those set aside, and that whole agreement has gone out the window. It doesn't happen all the time, but there are certain instances where there are legal reasons where your agreement should be set aside, even if the court has already signed an order adopting that agreement. If it's within a certain time, you got to remember the factors that led to your agreement are important, but also the timing is very important. You can't sit on it for a while and then go back. If you think you need to take back your agreement, you need to act quickly, and you need to call someone who can help you very quickly get the appropriate documents filed and give the appropriate information to the court about why your agreement should be set aside. All right, so you're going to a mediation. What do you need to know in preparation for mediation? The first thing is you've got to agree to be flexible. You're not going to leave a mediation with everything you want, any more than you'd want the other side to leave a mediation with everything that they want. Both sides are going to have to give. It's called a compromise for a reason, because you're going to give and take the whole day. And many times offers will go back and forth 3 or 4 or maybe a dozen times of, I want this piece of furniture, or I want the dogs, or I want this time with the children, or I want to pay this amount of alimony rather than that amount of alimony. There's all kinds of things that can play in to what you will be looking at in a day of mediation. So first of all, you got to be willing to be flexible. Second of all, you've got to have an open schedule, because a mediation can go quickly or it can take all day or even longer. The third really important tip is you need to come to a mediation by yourself. A lot of people will bring a girlfriend with them or their mom or a friend who they know has their best interest at heart and is really looking out for them. And I believe that person often has your best interest at heart, but they're not part of your marriage. And they don't know really at the end what you are going to be okay with. And they're a lot of times going to gum up the process of the mediation because they're going to have all kind of input that may frequently go against your lawyer's advice because that friend, that mom, that cousin who's coming with you, they've not tried divorces. They don't know the judge you're in front of, and they may not know what is in your best interest. That's why you've hired a lawyer to advise you about how to get your case settled. So don't bring friends, family members, or other people with you to the mediation because they're going to want to sit in the room with you. And oftentimes they're going to interject things that they don't really know what's in your legal best interest, even if they love you. Don't bring friends or family to the mediation with you. And finally, you've got to go into a mediation with an open mind, knowing that when two people are coming into a divorce, no matter what the trigger has been that caused the divorce, usually more often than not, there have been things that both sides have done over the course of a marriage that have contributed to this. And both sides come into a mediation with hurt feelings. Both sides come into the mediation feeling like they're on the moral high ground and they have a right to demand certain things. Go to a mediation with humility. Go into a mediation with an open mind. Go into a mediation by yourself, along with your lawyer, and go into a mediation willing to be flexible throughout the day. And then you could have a successful resolution to your divorce case. If you're at the point that you're ready to file for divorce, both you and your spouse probably know that this is coming. And neither one of you may be able to afford a contested divorce. You may not want to invest the time that's going to take to fight it out over months. And you may be able to reach an agreement prior to the time that you file a divorce with the court. Now, that doesn't mean you can reach a non-contested agreement that we're just happy and we get along about everything, but you may decide with your spouse to go to a pre-divorce filing mediation. That's something we can certainly help with in our office to make sure that you are represented in that, and we can line up the mediator and make sure that both sides are able to go and reach a compromise that works for both of you. And then once that agreement is done, that divorce agreement that is signed even before the divorce is filed can be submitted to the court along with all the other appropriate documentation to make sure the court can adopt that agreement as the order of the court. And so even if you're not quite to the point of filing yet, you and your spouse may want to consider a pre-filing mediation. If you have any questions about a mediation or settlement negotiations in your case, reach out to us right now.